Mr. Mayor, we're live.
Thank you very much, Madam Clerk. I'd like to welcome everyone in chamber and at home for joining us for the special council meeting of Wednesday, October 16th. Before we read the land acknowledgement, I'd like to take care of a few housekeeping items. Please silence your cell phones while in chamber. And members, when you come forward to the podium to speak, please take time to adjust the mic to make sure you're talking directly into the mic, as this meeting is being live streamed and it will be recorded for YouTube afterwards. The Township of Oro-Medonte acknowledges that we are situated on the traditional land of the Anishinaabe people and ancestral territory of the Huron-Wendat. The Anishinaabe include the Odawa, the Ojibwe, the Potawatomi nations, collectively known as the Three Fires Confederacy. It continues today as the home for diverse Indigenous people, including the historic Métis community in Penetangwishing. The Anishinaabe people continue to have an enduring relationship with this land, specifically the Chippewas of Rama First Nations, the Chippewa Tri-Council, and the Williams Treaties First Nations. The Huron-Wendat Nation also continues to pay respect and protect the ancestors and heritage on this land. We honor the Indigenous history and culture that has thrived for millennia in this territory and the treaties that bind us together as partners in the spirit of a shared, sustainable, and prosperous future. We are all treaty people. Our commitment begins with acknowledging the truth so that we can move forward together towards reconciliation. Miigwech. May we have a draft motion to adopt the agenda, Madam Clerk?
Moved by Lavoie, seconded by Hutchison. Be it resolved that 1, Section 3.3E of Procedural Bylaw Number 2023-043 be waived, and 2, that the agenda for the special council meeting of Wednesday, October 16, 2024 be received and adopted as amended to replace item 5B, Paul DeMello, Solicitor, Partner, Kagan, Shastri, DeMello, Weiner, Park LLP, with Gerald Spencer, Manager, Municipal Law Enforcement, City of Niagara Falls.
Thank you. Just for clarity, Mr. DeMello was unable to attend the meeting, and Mr. Gerald Spencer, Manager of Municipal Law Enforcement from the City of Niagara Falls, has agreed to attend to share his experiences. So the motion's read. All in favor? Opposed? That is carried. Members of council, are there any disclosure of pecuniary interest at this time? Councillor Schell.
Yes, thank you, Mayor Greenlaw. Regarding items 4A and 5B regarding short-term rental accommodations, I have to recuse myself as I own and operate a short-term rental income property.
Okay, thank you very much, Councillor Schell. Any other pecuniary interest? Seeing none. Okay, so we're now at item 4, reports of municipal officers for information only. Mr. Van Corner, would you like to speak to this matter? And if you just want to give a second for Councillor Schell to turn his camera off. And thank you, Mr. Van Boncourt. Whenever you're ready, you can proceed, please.
Thank you, Worship. Good afternoon, members of council. I'm going to provide a little bit of a context for what's going to follow my report this afternoon. In March of 2023, council passed a motion directing staff to pursue a number of action items to deal with short-term rental commercial accommodation, STRs, in the municipality. My report and the presentations to follow are to inform council of the challenges of enforcing STRs using a zoning bylaw. In March of 2020, the township attempted to introduce a definition of commercial accommodation in its zoning bylaw. In March of 2022, the amendment was struck down by the Ontario Land Tribunal. In March of 2024, the Divisional Court indicated its support of the tribunal decision, recognizing that the current zoning bylaw 9795 already prohibits commercial accommodation in dwelling units, but stated it must be something other than simply renting a dwelling unit for money. The court went on to suggest that the term commercial accommodation in the current definition of dwelling unit could mean that temporary accommodation provided as part of an ongoing commercial enterprise akin to a hotel, motel, resort, or bed and breakfast are prohibited as commercial accommodations. In the fall of 2023, Municipal Law Enforcement initiated 2 charges under the zoning bylaw through the Provincial Offences Act, the POA. In early 2024, as staff were preparing to proceed to court to have the provincial offense charges adjudicated, the township prosecutor determined that the evidence gathered to support the 2 POA charges against the operators of STRs was not sufficient to obtain a conviction and withdrew the charges. The divisional court decision has led to the expectation that municipal law enforcement can simply gather the required evidence under the zoning bylaw about an illegal STR, press charges, and secure a conviction. Unfortunately, it is not this simple. Staff have asked 2 individuals to share their experiences with the enforcement of STRs using a zoning bylaw as a tool. One will speak from the perspective of an experienced municipal law enforcement officer, and the other as an experienced prosecutor of Provincial Offence Act matters. Thank you, Your Worship. I'd be happy to take any questions.
Thank you very much, Mr. Van Boncourt. Council, is there any questions at this time for Mr. Van Boncourt? Seeing none, Madam Clerk, could we have the motion to receive the report, please?
Moved by Young, seconded by Lavoie. Be it resolved that DS 2024-124 George Vademont-Coeur, Manager Planning, Special Projects, Council Education Session pertaining to enforcement challenges in addressing short-term rental commercial accommodations in the municipality be received for information only.
Thank you very much. Call the vote. All in favor? Any opposed? None. That is carried. So this brings us on to Section 5, presentations. The purpose of our meeting today is to provide council and the public exponential information on the challenges and opportunities of enforcing short-term rentals. Using a zoning bylaw as the tool, we have initiated 2 individuals with significant experience in enforcing the bylaw as it pertains to STRs and prosecuting individuals that have been charged. This is to be a general discussion reflective of the fact that STRs are an issue in municipalities across Ontario, and recognize various municipalities have employed bylaws in different ways and are at different stages at this time. My request to those who ask questions is to please keep the questions general and related to the presentation and not a specific property or local situation, and our presenters will do their best to answer. Please direct your questions through the chair. And now that we kind of know the rules of engagement, I will ask if Gerald Spencer, I believe, is going to present first. Gerald is the Manager of Municipal Law Enforcement of the City of Niagara Falls. Mr. Spencer, when you're ready, do you want to proceed, please?
Thank you, Mr. Mayor, members of council. Okay, I'm just willing to see whether you have that there. So that's good. So I'm going to do an overview of the strategies that we utilize here in the City of Niagara Falls to enforce vacation rental units here in the city. On August the 18th, 2021, the Ontario, I should give an overview. My name is Gerald Spencer. I'm the Manager of Municipal Enforcement. I've been in enforcement now for about 3 decades. So I've been enforcing all municipal bylaws within municipal government now, as I suggested to you, for about 3 decades. I was designated as a prosecutor of the Ontario Courts of Justice back in 2016, and I continued to enforce municipal bylaws. Most of my career was in the City of Toronto, and I've been here with the City of Niagara Falls for just over 7 years. So that's just a synopsis and an overview of who I am. And so I'm going to continue. So on August the 18th, 2021, the Ontario Land Tribunal here at the city approved the official plan amendment number 127, which amends the city's official plan to add the definitions and policies respecting vacation rental units. Now, when I suggest vacation rental units, I'm referring to short-term rentals. It's the same wording, except here in the municipality, we call them vacation rental units. You would call them short-term rentals. So a licensed short-term rental with up to 3 bedrooms is permitted in existing dwellings or dwelling units here in the city within the tourist commercial, general commercial, and commercial business zone, subject to regulations contained in the bylaws, section 2018-92. So if we go to the next page, how did we get here? So aggressive short-term rental platforms establish momentum of the industry with other municipalities. So this is, as you suggested, it's a concern in not just this municipalities, but many municipalities throughout Ontario, thus allowing an easy transition into the municipality. So prior zoning bylaw language and the inability to aggressively enforce these prior bylaws through the courts. And I'll speak to that a little bit more later, and I'm sure Mr. Dre will speak to that in terms of a prosecution perspective and why it's difficult to enforce them. And there are definitely evidentiary hurdles that you have to deal with in order to enforce them adequately. So vacation rental units, they're a global trend. They're not a fad. They're a real industry that we need to address. There's more than 6 million of them worldwide. There's 450 million people use vacation rental units on an annual basis. 23% of Americans have used a vacation rental unit platform. The Marriott Hotel is the largest company, and it has 60,000 vacation rental homes in addition to its traditional hotel assets. So it's a very big industry. The city has access to software that identifies approximately 1,000 current active illegal VRUs. So here in the city of Niagara Falls, we have approximately 1,000 of them that are operating illegally here in the city. The rental channel of this software, so we utilize a software program which we can speak of and I can provide to the CAO at a later date. But we use this software and it depicts that 80% from the Airbnb site. So we use the various websites. I don't really want to name the sites, but there are various websites that we utilize, we look at in terms of who's renting them, or where they're renting them, and how they're renting them. Oftentimes we have challenges because they'll obscure the frontage of the property, so we don't identify exactly what the location of that property might be. And they might send that out to the person that's actually renting the property. So there are certainly challenges and hurdles that we've had to overcome here in terms of the database program. So through the use of this database website that we utilize, we can analyze market level trends, demands, daily rates, and occupancy rates. I am assuming that this data program is, you could use it in your area. I'm not sure, but that would be something that we'd have to speak about at a later date. We use the site identifies an occupancy rate, 45% generally here at the city of Niagara Falls. Municipal law enforcement staff, they utilize, review this platform and other platforms, such as the VRBO and Airbnb, to address concern. This platform redirects to those platforms. So basically, we use a web-based programming system that tracks the various platforms and web-based systems so we can identify where exactly short-term rentals are here in the city. So the next page. So the software we use, you can see that the software that we use suggests that we have quite a few here in the city. So we're complaint-based, so basically we understand that there's quite a few here in the city. If we receive a complaint, because of staff resources, we'll address those concerns and we'll do an active investigation on those complaints. So as you can see, the city of Niagara Falls has quite a few illegal short-term rentals that are currently operating here in the city. Our approach, next slide. Our approach is currently we send legal registered notices to the owners. So when staff go out and do inspections, they'll observe vehicles, they'll observe lock boxes on doors, they'll have a conversation with the renters, and that'll spark a notice that we issue to the owner of the property. So we'll issue legal registered notices to the owner. We also send notices to the financial institution as a security interest in the property. So if there is a mortgage outstanding on the property, we'll identify it with the mortgagee that there is potentially a short-term rental and or vacation rental unit operating at this address. Should staff acquire the adequate evidentiary requirements, and we can touch more on that, and I'm sure Mr. Dre will speak to that more, then we'll issue a Part 3 summons to the owner and the operator for non-compliance of the bylaw after the legal letters are issued. The first offense here in the city is $50,000. The second offense of each subsequent offense is a fine of not more than $100,000, and that's through the POA process. The Ontario Courts of Justice are apprised of the minimum and maximum fine submissions through the courts, through the legislative bylaw process, and obviously we're at the mercies of the court. So any monies or fines that are accrued is through the justice of the peace and the court system, and we're at the mercies of the court once we bring it to the court. Accountability, so the next slide. So we identify key performance indicators. So we track everything that we're doing in terms of, vacation rental units within a specific neighborhood and or neighborhoods. Core statistic analysis of fines that we've received, legal letter issuances to the owners, and any financial institution has a security interest in property. So we keep track of everything that we do here at the city, all the Part 3 matters that, Part 3 meaning Part 3 summonses that we issue to the various owners that are operating an illegal vacation rental unit. So we just keep track of everything that we're doing here in the city in terms of key performance indicators. And to summarize it, it's short but sweet. It's a resource of intensive action. So what I mean by that is, as you suggested earlier, and I heard the speaker speak to this, that it's often difficult to obtain the necessary evidence for vacation rental units. And the reason for that is the hearsay provisions in the POA court. So in terms of the POA court system, you have to be able to prove beyond a reasonable doubt that the individual is operating a vacation rental or short-term rental within a specific property. To do so is somewhat complex. I don't want to give out the specific details on how we do and why we do what we do, because I don't want to release how we do what we do to the public, but I'm sure Mr. Dre is going to touch on that and speak to that at greater length in his presentation. And we have resources restrictions. So we understand that there is quite a few vacation rental units here in the city. As I said earlier, we're complaint-based, so we don't proactively enforce them. They fluctuate at times because there is, once we just recently did a proactive enforcement action on them where we issued 20 Part 3 summonses, and we use the platforms to address it, and Mr. Dre will speak to that more. So what I mean by this is that we address it through the licensing platform and the advertisement platform. We find it very difficult to approach it any other way than through the licensing platform and advertisement platform. And what we do with this, and what I mean by this, is that we'll check to see whether or not an individual is advertising, because if they can't advertise, effectively you shut them down. So we approach it by way of a licensing and administrative through the advertisement provisions. Now we are moving, and Mr. Dre will probably speak to this, to an administrative monetary penalty system. We call it an AMP system. And the city as a whole, we're moving in that direction for next year. So basically, it bypasses the POA court system, and we do everything in-house. So we have to obtain a screening and hearings officers, and any monies collected by way of the AMP program is retained by the municipality. And again, Mr. Dre in his presentation will speak more to that. And that's basically my presentation, Council and Mr. Mayor, in a nutshell.
Thank you very much, Mr. Spencer. Council, what we'll do is we'll hold off on questions until we have both presentations. So at this time, I'd like to call Paul Dre, if you could come forward. Paul is a prosecutor, Provincial Offences Act, president of Paul Dre Legal Services, professional corporation, and he is the other lever in the formula. You have law enforcement once it's charged, and then Mr. Dre is the prosecutor that hopefully comes out with a positive verdict. So anyways, Mr. Dre, when you're ready.
Thank you, Your Worship, and thank you, Council, for having me here. I'm not used to talking, and I have my back to a whole bunch of people, so I apologize for that, but I guess you can, I don't know if they can see me up there or not, but certainly you can hear me. And the first thing I'll say is that I've been at this quite a few years, too many, but I worked for the city of Brampton. That's where I worked for many years. I was in legal services, and I was a prosecutor. And so, back in the day, the flavor of the day in Brampton was basement apartments. So we went through, a great process in Brampton with regard to basement apartments and prosecutions. Now, I still work in prosecutions, and I retired, but it didn't go very well. And I'm still working doing prosecutions for a number of municipalities, and I'll talk about that. My background is I was in enforcement. I was a police officer, and subsequently I went with the city in enforcement. I also worked in the planning department, which certainly helps. I was what was called a zoning plans examiner for the city. I did that for a year. It's a year I'll never get back in my life. But having said that, it really gave me an understanding of zoning and understanding zoning and the terms and the terminologies and so on. So that's a bit of my background. I work for a number of smaller municipalities, but I also do work for cities, and I did work with Gerald in Niagara Falls. And the key to Niagara Falls' success, if there is a success there, is that number one, they made sure their zoning bylaw was in place and correct. So it limited where they could go. They really dealt with it. They don't call them STRs, but they call them vacation rental units. But they did their zoning bylaw first. They got that in place. They got a good zoning bylaw in place. And then what they decided to do was to go to licensing. So I'll talk about that a little later on. With regard to STRs, and when I say this, they're a problem all over. When I say a problem, it's sometimes municipalities, overreact to some problems. And, in some cases, I would say, and this won't be popular, I'm sure, but in some cases, we try and kill a mosquito with a sledgehammer. And, they've been around for many years operating, and it's because of a few that the restrictions are going on so many. And there are major problems with STRs, and I understand that, but it's not with all of them. It's with the minority of that group. And so some of the issues that people deal with in STRs, and they can be dealt with outside of the zoning bylaw, are some of the smaller municipalities in the north. They didn't have their zoning in place and or licensing, and so they dealt with things like noise. So I had noise trials where somebody rents their property, 21 people one weekend, 32 another weekend, so the noise, and this is in the north where noise carries, so they dealt with the noise. Other places where there's the city, they deal with parking. So parking on the lawn is zoning, but it's easy. You're parked there, there's your car, you're on the lawn, that offense is easy. So, people dealt with them different ways. I'll just go through some of the areas that I prosecute for. Collingwood, and with Collingwood, they have a bed and breakfast license right at the moment, but not STRs, so they're still doing those through the zoning bylaw right at the moment in Collingwood. I'll just give you this story of one, and I'm going to get to the problems, but one of the easiest ones I had was in Collingwood, and it was in a condominium. And in that condominium, the rule said you can't rent out short-term rentals. So nothing to do with the bylaw, nothing to do with the municipality. It just had in the condo rules, you couldn't rent your unit for short-term rental. And so in that particular case, what the condo board did, and I'm speaking about this because it's been through the court and it's been dealt with. So it's all public. What the condo board did was they had one of their people who lived there actually rent the unit and got all the paperwork, everything from the owner. And so when it came to court, the lawyer on the other side, they get disclosure, full disclosure. And so we gave them full disclosure. It had nothing to do with the city or the town going in and hiring somebody or going in as an officer. It had to do with them doing it. And once we gave disclosure, the lawyer on the other side, what are you looking for, Mr. Dre? And we said compliance, and they said, well, that's what we'd like too. And the people actually put their unit for sale and moved out of that particular condominium. So that's a happy ending to that story. Some of the other municipalities that I deal with, I used to prosecute for all of the municipalities. When I say all, most of them around Parry Sound. And so one of the places there was depending on their zoning bylaw to do it, but they were doing it through injunctions. And injunctions can be very expensive. And they were relying on the commercial aspect of STRs. But nowhere did it say in their zoning bylaw that commercial had anything to do with it. And the lawyer at the time, I mean, they were successful in the 3 or 4 they did because nobody filed a defense. They just decided to acquiesce. So then they felt that they would get me to prosecute them. And I looked at their zoning bylaw, and I looked at what they were trying to do, and I determined I wasn't going to take any of those on, as there'd be no reasonable prospect of conviction. There was nothing in their zoning bylaw that dealt with the commercial aspect, although council believed it was a commercial aspect. There was nothing in their zoning bylaw. So I won't name that municipality, of course, but it was one of the 6 up there that I deal with. Niagara Falls, as I said, they went through the process of zoning at the land tribunal, and they were successful. And in that, the tribunal said, no, these are different than a residential use. And they determined that they are different, and there's certain areas that they should be put in. And that's where Gerald spoke to, that they are put in certain areas where commercial, general commercial, don't quote me on that, Gerald knows better than me, but that's where they were put. And so once they got their zoning bylaw in place, they contracted me to write their licensing bylaw. And so I did their licensing bylaw for both bed and breakfast and for short-term rentals. And I'll speak about it now, but I'll speak about it later as well. But one of the things in the licensing bylaw is that it's an offense to advertise when you're not licensed. So now, when I get to talk about the constraints for zoning, now we can put that advertisement from the internet into court. When I get to the zoning part, we can't. It's hearsay. And so just by advertising on a platform, and just to take this a step further in that is that I sit as a hearings officer for Vaughan. I did for Richmond Hill. I sit in Newmarket. And that's for this AMPS, which I'll talk about later. But I saw something in the Vaughan bylaw, and what a wonderful section. And it said, if you advertise on a platform, you're deemed to be operating the bed and breakfast or the STR. So unless there's evidence to the contrary. So when somebody advertises, we don't even have to prove that somebody stayed there. They're deemed to be operating because they have a schedule of things there. And it's, I believe, and Gerald can speak to this, but I believe it's been very successful for them down there in enforcing that. Let me just go on to the others, and I'll be very quick with those. I work for Tiny Township as well. They amended their zoning bylaw to deal with it. They are allowed in any area, but they went to the licensing, and their licensing, or pardon me, their bylaw is currently under judicial review, or an application for review at the Superior Court. But notwithstanding that, I think I have about 40-some prosecutions of short-term rentals. We have not lost any yet, but most of them have pled guilty and have discontinued and decided not to license. So in all fairness, I'm not that wonderful a prosecutor. It's just the people have said, hey, I don't need this. I don't need the court. And they've decided not to continue. The town of Blue Mountains, They were one of the first. And if you think of the Collingwood ski hills, Blue Mountains is basically, they call it the Collingwood ski area, but it's really all of the condos and so on there are in the town of Blue Mountains. So they were one of the first, and they, again, had their zoning bylaw where they could be, and so they allow them in those ski areas and so on. But then they went a step further, and they went to licensing, and then they went to AMPs, which is administrative monetary penalties. So I worked with them on their licensing bylaw and with their administrative monetary penalties for Blue Mountains. Wasaga Beach, they actually license. It's a business license, and in Wasaga Beach. So that's sort of the gamut of some of the ones I deal with. Just so everybody understands, and I think most people do, but zoning involves the use of land and people's rights to use land. And the land that most of these are on is residential, and the use is residential. Although it's a limited use, it's still residential. I know your bylaw, when I say that, your bylaw of Oro-Medonte has a commercial component to it, but it's still a residential use, and they talk about a residential dwelling unit. And so those are some of the things when I talk about zoning and successful zoning prosecutions and ones we have problems with, it's all based on those definitions. So in order to have a successful zoning prosecution, the first thing is you have to identify the property. And that, Gerald alluded to it, that sometimes, and I believe Mr. Vadeboncourt alluded to it as well, that many times they don't put a picture in the STR of the property that goes to the renter. So that makes it difficult to prove, what property it is. But we've been very, very successful in Tiny. An officer goes out, takes pictures. There was one that showed the beach and the side yard in the pictures on the internet. And so the officer went to the side yard, took a picture, and it was identical to what was being advertised. So, we could prove that that was the property. Then ownership of the property, which again is easy to prove. You do a title search and you find the owners of the property. Just to divert a bit, sort of an interesting one I had in the north, somebody rented a cottage for the summer, for the whole summer. And the person thought, whoa, this is wonderful. I have a renter for the whole summer. Well, yeah. The renter then put it on Airbnb and did short-term rentals. So his first rental paid for the whole month, and nothing but problems with noise and a lot of issues. So, when you're in that business, you really have to be careful. The other part it's the proof of use. And so that's the hard part, is the proof of use for zoning. And problems with proving the case. And I say to officers quite often, officers lay charges based on what's called reasonable and probable grounds. So the officer believes it's being used that way, and they speak to a renter, at the property and so on, they can lay the charge. But now it comes to me and I go, how are we going to prove this? So some of the things that are really, difficult to prove a case, and the first one is when the officers go and speak to the people at the property, they get their names, they get their addresses. Oh, I'm from Michigan, and they get all the information about the people. Well, we can't put that in court. That's hearsay. Unless that person comes back and testifies, we can't put it in. We can't put affidavit evidence in. It's a criminal court system. It's quasi-criminal, but it's criminal system, and we can't use that. And it's very frustrating. We all know what's going on, but to prove it is sometimes more difficult. So I'm just saying, in some cases, the other thing that really, ties the municipality's hands is if you're using zoning, and I did print it out here. I want to go over it, sorry. My apologies. I put it in my pile, and it's Section 49, subsection 3 of the Planning Act. And I wanted to read it here today, and I'm sorry, it's not coming up to the top of my pile. If I find it, I will certainly read it. But basically what it says is that an officer or any person that is used by the officer to enter a dwelling unit has to tell the person they have the right to refuse them entry. So when they go, if they're trying to do an inspection inside to see what's going on, very difficult, because that section says you have to tell them they have the right to refuse you entry. So then that's, problematic. I've talked about advertisements from the internet, problematic, and say, well, we've got the advertisement, there it is. But anybody can put things on the internet. If I don't like you, I could put an ad for your house for rental on the internet. So it's hearsay, and unless you have the person who did it, you can't put it into court, and it is hearsay for court. Many times too in zoning, it's not as simple as one would think, because again, it's land use. And the court has to determine whether that use, for example, based on your definition, is commercial, like a commercial component. So lots of times you have to have experts there, a planner, come from the municipality to give evidence to the court on interpretation of that particular bylaw. Again, I've done it before, we've used planners, but again, it becomes expensive for the municipality, because now you've got expert witnesses, you've got all those things that go along with zoning that you have to prove. The other thing I'll just mention is zoning bylaws, and George won't like this, but zoning bylaws are written by planners, and they're not written generally by enforcement people. So there's things in zoning bylaws, and if you look at the definition of your dwelling unit, it says used or intended to be used. How in God's earth would we ever prove in court that a person intended a use? You can't. Why they put that in, I don't know. Yours actually clarifies it, because the second part says, or capable. And those are the words you need in there, is capable of being used rather than intended to be used. So words sometimes really play, and that's why that commercial component in your bylaw is somewhat problematic for zoning. And let me just give you an example of the zoning bylaw. So somebody in a residential area decides at Christmas time, let's get a load of Christmas trees, and we'll dump them on the front yard, and I'll sell Christmas trees from my house. And so they get a complaint, the neighbors say, wait a minute, what's going on here? So the officer goes out, and there's a sign that says Christmas trees. Well, he's selling Christmas trees, so that's not allowed in the zoning bylaw because it's residential. How do we prove that he's selling Christmas trees? Unless we see money change hands and somebody goes in and tries to buy a Christmas tree, that whole thing doesn't work. But under zoning, you could say outside storage of goods and materials, not accessory to a residential use. So like zoning is not just this simple, somebody selling Christmas trees or operating a landscape business from their property. It's very, very difficult, because how do you prove they're operating a landscape business? Do you have bills? Do you have that they go out from there? Like, it really is difficult. But if they're storing stones and gravel and machinery there, the outside storage of goods and materials, not accessory to a residential use. So there's many ways of approaching zoning, but for STRs, it's pretty limited. But those are some of the constraints. Let me just talk about licensing as opposed to zoning. And Well, let me just talk about something, legal nonconformity. So legal nonconformity also applies to zoning matters. So somebody says, well, I rented this out 35 years ago or 40 years ago. They may well have a legal nonconforming status under zoning. But if you go to licensing, there's no legal nonconforming status. You still have to license it. Even if you prove it was legal nonconforming, you still have to license it because that's the rules today. So, you know, that sort of takes away that legal nonconforming. It's still legal nonconforming, but you still have to license and go through that. Terms and conditions on licenses. I see these because I deal with Tiny on an ongoing basis, but they have number of bedrooms, length of stay, number of renters. Some Blue Mountains and both Tiny have, Blue Mountains calls it a demerit point system. So if they have a noise complaint from your unit, you get, I think it's 5 points. And if you accumulate the 15, something like driving a license, you lose your license. So I'm not giving those exact numbers, but that's their system. And Tiny has the same system, that if you violate and then there's a conviction, then it goes against your license. The other thing is, if somebody's causing all kinds of problems and at the unit, the licensing bylaws usually say, as a result of their actions, the council, or pardon me, the town can decide to revoke or not renew their license. So that's another something that you can use. I think I've covered off the advertisement for licensing and so on. The third thing I just want to talk about, and I'm not going to talk about it at great length, but a lot of municipalities are going to what's called administrative monetary penalties. And you've heard Gerald speak about that, and they're going to them in Niagara Falls next year. And Vaughan, for example, have those where I sit. Richmond Hill have those. And, well, many municipalities have them. And basically, it's a system where it's not a court. And so there's no guilt or innocence. And the standard of proof is not beyond a reasonable doubt. The standard of proof is a balance of probabilities. And so that's where the Vaughan one, that if you're advertising it, it's on a platform, you've got the schedule of when it's rented, then you're operating it. The municipality doesn't have to prove that people were in there on those dates. They've got that, and that's in front of the hearing officer. Hearsay under administrative monetary penalties is admissible. So you can put things in under the Statutory Powers and Procedures Act. You can put things in that you couldn't put in under a court. So it's the balance of probabilities, 51 to 49. And I make those decisions on a regular basis. I sit and I make those decisions based on, let's just use a parking as an example. The penalty notice is issued. They take 4 pictures, picture of the sign, picture of the vehicle, and the street. And so on the balance of probabilities, if it says no parking and there's an arrow and your car is parked there, pretty hard to defend that. So on the balance of probabilities, you're going to be found not guilty, but the penalty notice is valid. So that's just a little bit about that. The other thing I'll mention too, with zoning and with anything that goes to the court, COVID, I'm trying to find the proper word here. As a result of COVID, things got all backed up in the courts, and they're still backed up. So if you think you're going to get a zoning or a licensing or any procedure through the courts quickly, you're not. It's going to be at least a year or more, and people really get upset because somebody's continuing to operate, and it's, we're trying to get it through the court process. I can't get days for trial. It's just, it's very frustrating. So I deal in Barrie and Aurelia. So I deal with Tiny, Springwater, Midland, Wasaga Beach, Collingwood, all those places go to those courts. and trying to get trial time is almost impossible. So you try to resolve things if you possibly can. And for the municipality, at the end of the day, what you want to do, I believe, is get compliance. So if it's in an area that can't be licensed and they can't get a license, then you've got to stop your activity or stop your behavior. But if it is, then you want them to get a license. And the other thing I will say about licensing, it does relieve the municipality of some of the onus of safety concerns because of building, fire, and so on. So smoke alarms, CO detectors, all those things. I know in Wasaga we've had a number of charges that fire because people get in there in a cottage type situation, and they have the smoke alarms go off, so they just disconnect them, So, there's charges there and so on. So for a safety perspective, smoke alarms, CO detectors, and those things are important. In conclusion here, before I take questions or before we take questions, the issues that I believe council has to deal with or grapple with is, do you continue as you're presently going? And I think you've sort of run against a kind of a brick wall there with regard to that, because I don't know how in God's earth you're going to prove that commercial aspect. And if we just think of the commercial aspect, you have to have some evidence that is commercial. You have no rights to books or records. You have no right to know how much it's rented for or not. Is it commercial? Is it, it's really hard to prove that aspect of it, just like it is we're selling Christmas trees or operating a business from your home. Really hard to prove those things under zoning, so just be aware of that. So continuous present and my suggestion is the key to short-term rentals, and I give this advice to all of my clients, get your zoning bylaw right, where you want them, and have the definitions right in there. Once you've got that, then you can decide, do we go with the zoning or do we go with licensing? But you've got to get that zoning bylaw right. And right at the moment, I believe, as a prosecutor with 35 years experience, I would likely make the same conclusion as the prosecutor did. There's no reasonable prospect of conviction if we don't know we can prove the case. So again, I say we all know that somebody's guilty, but we have to prove they're guilty in court, and that is really, really difficult in these times. And the bottom line is either determine where they're permitted in your zoning bylaw. My recommendation, I'm giving legal advice on the fly here, and I shouldn't be, but that commercial accommodation is problematic, as I see it as a prosecutor. But maybe your prosecutor or somebody else doesn't see it that way, but I certainly would in trying to get a conviction in court. So, and consider licensing once you've got that in place, if you choose to do that. So that's my presentation.
Thank you very much, Mr. Dre. We'll receive the two reports, Madam Clerk. So could I have the motion for that first, and then we'll move to questions, please.
Moved by Clark, seconded by Young. Be it resolved that the presentations provided by Gerald Spencer, Manager of Municipal Law Enforcement, City of Niagara Falls, and Paul Dre, Prosecutor, Provincial Offences Act, President, Paul Dre Legal Services Professional Corporation, re Short-Term Rentals, STR, be received.
Okay, Council, all in favor? Opposed? That is carried. Okay, so now we're on section 6, which is questions from members and of the public and council. So just to have a structured order, first we'll have questions from members of council, followed by we'll open the floor up for the public to ask questions to Mr. Dre and Gerald Spencer. I do ask though that the questions stay specifically to the presentations, and we don't deviate into specific properties and past history within the township. So I think we want to stay focused on moving forward and as we look for a sustainable path. Okay, so council members, any questions? Councillor Clark?
Thank you, Mr. Mayor. Through you to Mr. Dre, if I may. You had spoken about AMPs or administrative municipal penalties, but the language in the legislature in which to allow those to happen says that they can't be punitive in nature. So in essence, in theory, STR operator could just tack that on as a cost of doing business and pay the consistent administrative penalty in perpetuity. Is my understanding correct?
Yes and no. Let me just backtrack. I should have said this when I was speaking. If you're going to use administrative monetary penalties, you cannot do them in zoning. So they cannot be used in zoning. The reason for that is the Planning Act does not allow for them in the Planning Act. The Municipal Act does, and that is for licensing. So if you did the licensing, you can use it, but if you used the zoning, you cannot do administrative monetary penalties. To go to your position with regard to AMPs, I sit in Vaughan, and so when they do an AMP, it's $750 per administrative monetary penalty. So when they do it, they do one for operating without a license, one with failing to register with the municipality for the tax basis, and the third one I just forget, but they usually lay 3. So it's quite substantial, like each time, and you can put in your administrative monetary penalties that there can be escalating penalties in there if you wish. But I mean, that's totally up to you. I write those, we write those bylaws, but again, that's up to the municipality.
Okay, thank you. Any other questions? Councillor Young?
Thank you, Mayor. I just want to ask a couple of questions, several questions. Yeah, several questions. One of them, Mr. Spencer, as well as yourself, indicated that the test for proving the case is beyond a reasonable doubt. As you know, as a former police officer, that's more criminal. That's the test of proving a case in court. So it's much more difficult, as you know, to prove that a criminal offense. And again, the court takes the position that beyond a reasonable doubt. So why is the test? This is administrative. It's a provincial offenses court, and as you indicated, it's on the balance of probabilities, or it's more likely than not that the offense was committed. So what's going on?
The difference is that the Provincial Offences Court operates on a quasi-criminal set of rules. So when we're in Provincial Offences Court, it's not criminal. They can be bylaws, they can be whatever, but the rules for proving that are the criminal rules. Once you go over to hearings, administrative law, then it turns to the balance of probabilities. So administrative law, in terms of when you think of the land license or the appeal tribunal, that's administrative. Well, locally you have property standards, that's administrative. Property standards appeals. You have committee of adjustment appeals, or pardon me, hearings. Those are all administrative law, and that's on the balance of probabilities.
Supplemental?
Yeah, thank you. I'm just surprised to hear that that's a standard of proof in a provincial offences court. Again, it's more administrative than criminal, but I'm surprised to hear that it's quasi-criminal or quasi to that. But I just got another question here for you, if I may. Mm-hmm. You indicated that you obtain the mortgage particulars, and how do you obtain that? It's a private matter. So I understand that you can identify who owns a residence or house, but how do you get the mortgage?
That's from the abstract page. So it says who holds the mortgage, the Royal Bank or the TD Bank, and it says how much the mortgage is. So I'm not involved in that, so I could turn that over to Gerald, but it comes from the abstract page from the Land Titles Office. Yeah. So it tells you what the mortgage is, and that's kind of useful in some cases because in prosecutions, you always try to look at, do they have any equity in the property? And sometimes the mortgage is greater than the equity they have in the property. So if you think you're going to get your money as a municipality, you know, you're dreaming in Technicolor.
One more question?
Yes, I got a couple more questions. Yeah, as you mentioned that, it does ring a bell with me that I've looked at those documents as well in terms of who's the mortgage holder. But do you look at who's holding the insurance? Because mortgages have to be insurance. And I could just tell you, as a former fire marshal, where there's a house burns down and the mortgage company gets involved, and they're most instances unaware of the fact that it's a commercial that's been rented commercially. And I can tell you that the owner has a great deal of difficulty once the insurance company finds that out. Have you had that experience?
There's some, I've heard, again, I'm the prosecutor, so I don't really get into that. But having said that, if you breach the terms and conditions of your insurance, and so I know in mine, I'm insured by Bel Air Direct, and I cannot have a commercial use in my house unless I insure that commercial use with them. So, you know, if I had a fire and I was renting it out, they're not going to cover me. So, you know, like, I'm aware of that, but a lot of people may not be. I don't know.
Just continue till you're finished, Councillor Young, please.
Yeah, thank you. I just wanted to ask another relevant question that you mentioned licensing, and as you well know, that a number of municipalities have licensed them on the condition that the owner reside in the residence there. Just a comment, the difficulty is, how do you prove that he is living there? I mean, you know, you knock on the door, he's not home right now, you knock on the door, he's on vacation right now, you know, the list goes on, he'll be right back type of thing. And it's difficult if a place were to be licensed to prove that the owner resides there. And just because it's licensed, as you well know, it doesn't stop the noise and all the rest of that from occurring.
No, that's it's problematic. I can't solve all the problems, but having said that, your bylaw can address that that this is their principal residence, and put some teeth in there that because people say, oh no, I live there, and they have another, you know, for their driver's license and for all their other cards and their tax return, it's their principal residence is somewhere else because this is an investment property. There's capital gains. There's all kinds of things that go on there. To answer your question even a bit further, we had a couple cases in Wasaga Beach where somebody says, oh, no, I live there. And the officers went at 2 a.m. in the morning and there's nobody there. And so they're not out to a variety store. They're not out to, you know, just, and in many cases, the tenants say, well, nobody's been here, you know, the whole time. Again, you can't use that, but again, you come back to the person and say, hey, you got to live there if you're going to rent it, you know, if that's what you put in your licensing. Bed and breakfast generally are different because, like, the actual bed and breakfast, they put that the person must live there. Short-term rentals, not so much.
Okay, please continue. Yeah.
Just one more question. You're aware that there have been convictions for short-term rentals. As you suggest that the accused will normally plead guilty to avoid having to go to court, particularly when there's preponderance of evidence that strongly suggests or indicates that they're guilty. You're aware of those. There have been convictions.
I'm sorry, I'm just not getting the question.
What I'm asking you is if I'm sure you are, you're very competent, obviously knowledgeable, but you're aware of the fact that there have been convictions for people operating short-term rentals.
Oh, by all means. I've received convictions, but if we'd been pushed to trial, I may not have got those, but the people say, you know, what are you looking for? And if they decide to discontinue, I know in Niagara Falls, and Gerald, correct me if I'm wrong, and some other places that the person signs an affidavit that they're aware their activity is illegal, and that is kept in the file. So if you get a conviction, that's really what you want. If they discontinue, if they continue after that, then you've got the affidavit, sworn affidavit, that they knew that it was an illegal activity. So some places use that, and it's a very effective tool.
Through you, Paul, through you, Mr. Mayor, to the councillor, I would suggest, yes, we do utilize that, but since we have the advertisement and licensing platforms, we don't need to use that anymore. We don't utilize that process any further. We now use the advertisement and the licensing platforms to enforce it, as opposed to the way we used to do it through the zoning provisional. And as Paul suggested, we would suggest the person, it was more difficult to prove it if the individual didn't plead guilty, as opposed if they pled guilty. And if they pled guilty, we would get them to sign an affidavit to suggest that they would do it again, basically. And ultimately, as Mr. Dre suggested, we as a municipality, we're looking for compliance. We understand it's a tough market and people are trying to make a buck, et cetera, but at the end of the day, you have to comply with the will of council and the specific bylaws within the municipality. So yes, to answer your question, Councillor, we use the advertisement license provisions. We don't use the zoning provisions any further as a result of the new bylaws that we've implemented.
Thank you, Mr. Spencer. Is that all your questions, Councillor Young?
That's all my questions. I got a comment though.
Please comment away.
I'll keep it short.
Okay.
Yeah, those convictions that I was speaking about, you're quite right, as you've indicated earlier, that the parties pled guilty. So there's been no test in the court. There's no prosecution in terms of introducing evidence, that sort of thing, in those cases where they're registered as a conviction.
There's one case, and I have the case, but I don't know with it's City of Kingston versus Patry, and it was again their zoning bylaw they went with, and people were renting, and they said friends or family or whatever, and they got the license plates of the cars and so on and the turnover, and on appeal, the appeal court said no, there's enough evidence here that it wasn't just a single family home. This wasn't their family. For people from Michigan and New York State and all the places that stayed there. And that's the only decision that I know, the appeal decision that you can kind of read that was under zoning.
Thank you. Just one question. Mr. Spencer, do you have a hard stop? I just don't want to, I want to make sure we get the questions to you before you have to leave.
So I have to leave, Mr. Mayor, at 5:45, but up until that point.
5:45. Okay, so I'm going to just ask at this point if there's some bylaw specific questions for Mr. Spencer, just so we can make sure we don't miss them at Councillor or Deputy Mayor Lavoie.
Yes, thank you very much, Mr. Mayor, and through you to Mr. Spencer. You indicated you had approximately 1,000 illegal short-term rentals?
Yes, that's correct, Councillor, approximately. They
And,
fluctuate, but approximately 1,000 or more.
and how many licenses have you issued?
So currently, I actually just checked today, so we currently only have 47 licenses that we've currently issued for legalizing vacation rental units here in the city. Now, we are looking at a new program moving forward to 2025 where, similar to what Mr. Dre suggested, a B&B application for vacation rental units or short-term rentals. So basically what that means is that you may be able to rent out your property as a vacation rental unit, provided that you reside there. So the city as a whole is looking at that program moving forward. We understand that we have quite a few, you close a few down, a few more open, you close a few down, a few more open. So we're on this endless cycle of closing them down, others are opening. So we understand that that's problematic. So we as a municipality are looking at licensing again provisions in terms of what we're going to do in the future. So we have a consultant that we're working with currently. I can't say the name of the consultant because I don't have a meeting tomorrow with them, but we're looking at an owner-operator type of use, similar to that of a bed and breakfast, if that answers your question. Yeah.
Yes, it does. Thank you. At this point in time, have you had the opportunity to establish what sort of a budget you require for prosecution, licensing, and enforcement? Or can you disclose it if you have?
Yeah, I mean, it's a substantial cost to enforce these bylaws. There's substantial time and effort that goes into every enforcement effort that we endure. But I can suggest to you that since we've implemented the advertisement and licensing provision and we address the zoning provisions, as Mr. Dre suggested, it's a lot easier to be successful in court in terms of enforcement actions that we take. And again, like as a municipality, we're complaint-based. So we don't have the resources and staff members to go through various platforms and proactively enforce various short-term rentals within the platform. If we did, we'd probably have a lot less than we do. But that being said, as I said earlier, we are very successful in enforcing them by way of a complaint, and through the advertisement platform, we shut a few down, a few more open. So we find we're in this endless cycle of closing and opening of enforcement in terms of vacation rental or short-term rentals.
Thank you. May I proceed?
Yeah, no, please continue until you're done.
Okay, thank you. Is there any indication from what you've been able to perceive so far that prosecutions result in some sort of deterrent for other operators? You indicated a kind of a whack-a-mole program, in essence, where a new operator would pop up in the presence of others. Is the number generally declining, or are things staying approximately the same? Or perhaps it's too early to tell based on where you are with your program?
I would say we've somewhat declined since we've introduced the whole advertisement licensing platform, but the word does get out through members of council, through council agendas, et cetera, that we are looking at a new program moving forward. So the word does leak that maybe perhaps in the future the city is looking at an owner-operator type scenario, which doesn't discourage people from operating illegally. In fact, they think because the city is looking towards perhaps maybe even a licensing type program or a B&B type program, it encourages some people to continue to do what they've done. But when we do a blitz, as we've done recently, as I said, we are complaint-based, but at times we did do one blitz more recently. We publicized it. When that does happen, you tend to see a drop in the rate of people that are currently advertised. And so yes, it's effective in some sense. It addresses the concerns of the neighbors. So what we as a municipality want to achieve is when a neighbor complains about a specific property, it's generally the noise, it's generally the waste and debris. The property in some ways are uncapped. Maybe there's a buck and doe and there's a major party and the police are involved. Those matters we want to address and deal with immediately, and we do that. So in some sense, we achieve compliance because the neighbors are satisfied. So in that sense, yes, we've achieved our goal, but no, we shut them down and then 2 or 3 more open somewhere else. So like I said, it's like a whack-a-mole, as you suggested. Does it deter? In some instances, I would suggest it does in certain areas of the city where we might have more complaints that are specific to vacation rental or short-term rentals. But it's really hard to say.
Thank you very much for that. I guess you probably touched a little bit on my next question, which is, are you finding that you're successful in shutting down or dissuading egregious vacation rental units where there are a lot of activities that are causing difficulty for the neighbors?
So to answer that question, I would suggest absolutely. So if we do have a contentious area of concern, we've been very, very successful with the neighbors in that immediate area to address those concerns. And that would be as a result, as I said, of noise and or waste or debris or parking concerns or issues throughout the streets. Those are the concerns. The ones we don't hear about is when, for example, like a bed and breakfast, people are policing their property adequately. They're cutting their lawn. They're making sure there's no parties or concerns or issues of anything of that sense. So maybe we don't hear about them because they're not a problem in the area. So the ones that we are dealing with primarily through the complaint program are the ones, like as I said, there's noise-related concerns, there's parking-related issues, there's, waste and debris issues. If you have 20, 30, 40 people over, they're going to have a lot of garbage. So that's the concerns, and we've been extremely successful in addressing those immediate concerns of the neighbors.
Thank you very much. There was an earlier point made that you had made some zoning bylaw changes prior to entering into a licensing arrangement. Were there any legal non-conforming uses that arose out of the bylaw changes that you made?
Well, I can suggest I'm not a planner, but I don't recall that there were any, because what we did, we as a right permitted them within the 3 areas of the city, whether it was tourist commercial, general commercial, and a commercial business zone. So I don't recall in those areas there were any legal non-conforming. In fact, off the top of my head, I don't think there were any, because as a right, we don't allow them in residential neighborhoods, and the complaints that we've received as a whole have always been generally in residential neighborhoods, because we are a tourist community, and some of our areas, we have, for example, on River Road, we have most of our bed and breakfasts, so we don't really generate a lot of complaints or concerns, because people are actually policing their properties adequately, and they maintain their grass, they don't allow for noise concerns or issues. So in that sense, I would suggest that there haven't been. I can't say for certain, but I'm pretty sure that there haven't been, to my knowledge anyhow.
Okay, well, I'll just make one more point or one question and open the floor up. There was a recent federal tax court ruling in the spring that indicated a property that had been used as a short-term rental, the buyer had to pay HST on it, even though it was a resale property, because it had been used for short-term rental commercial purposes. At least the federal court established, since it had been used as a short-term rental, that was a commercial use. They didn't get tied up in the zoning concepts, I don't think, to the same extent as we might. However, it seems to me that would be a good tool to discourage the short-term people entering into that business if they thought on resale that the buyer would have to pay an extra 13%. So anyway, I'll leave that with you folks. Thank you.
Thank you very much, Deputy Mayor Lavoie. Any more questions for Mr. Spence? Councillor Young.
Yeah, just a brief comment. Given that there's 1,000, I guess, in the Niagara Falls area, and 46 or 48 have come forward. And the reason for that is, of course, that there's a MAT tax, municipal accommodation tax, that would 4% has to be submitted to the municipality. And further to that, they'd have to declare that short-term rental income on their T4. So that's why a lot of them gone underground, so to speak, and operate it with a license, as has happened in Arroyo.
Thank you, Councillor Young. Mr. Spence, I just wanted to ask you one question. Like, with your licensing regime, do you set conditions such as days of rental, or is it strictly you're either a short-term rental or not?
Yes, you can't rent for less than 28 days legally if you're not legally licensed. So it's 28 days or more. You're permitted to have a long-term lease in terms of a lease agreement with an owner, but anything with 28 days or less, you have to be within those 3 areas that I mentioned earlier to legally operate a vacation or a short-term rental. So does that answer your question?
Okay, partially yes, but do you limit number of days a year or a month that they can rent, or is no? So it's open.
No, we don't limit it. Not within the legalized areas. We don't.
And do you have a demerit system in place for any infractions, such as nuisance?
No, we don't.
No?
Yeah, such as Blue Mountain. I know Blue Mountain does have a successful demerit program system, and I think Mr. Dre was responsible for implementing that system, so he's well versed in it, I'm sure.
Okay. I guess I'm looking for, and I know you're not going to get cost neutral on this, and I would also open this question to Mr. Dre. So is there any, what kind of dollars are you looking at for a municipality to implement a conditional or demerit system? Anyone can answer that.
Mr. Dre, do you want to answer that one? I think you're responsible for Blue Mountains.
No, I'm the prosecutor, so I don't have a municipal budget. But having said that, when you go to a licensing system, one of the things you want to consider is what is the license fee and what does it cover? So when you pay a license fee, it should cover the cost to the municipality. And I believe, and I'm doing this off the top of my head, but Blue Mountains are somewhere around $2,000 for a license. I'm trying to remember what Tiny's is. I do have their bylaw here, maybe it's in the back, but you want to try and cover off the costs of administratively and inspections and so on with regard to that.
Okay. Is there any other questions at this time for either? So I guess the one question I have is, Mr. Dre, so is the province the ultimate authority of governing land use?
No, they've delegated that to the municipalities through the Planning Act, Section 34, as I understand it. So you can pass bylaws to designate land use to the municipality.
But it's appealable, correct? So I'm saying, who has ultimate authority on land use in the province? Is it the it's been downloaded to the provinces from the federal government, correct?
And then it's been downloaded to the municipalities. Ultimately, you go now, it used to be the Ontario Municipal Board in Ontario, and now it's the licensing tribunal that they go to. And their decision is basically final unless, like Oro-Medonte found, that somebody makes an application that the decision on the land tribunal was wrong or whatever. So you always have the court, Superior Court, to go to, and then if you don't like that, there's the Court of Appeal of Ontario, and then the Supreme Court of Canada. So,
yeah. Unfortunately, we've experienced it's very expensive.
Yes, it is very
and time
expensive.
consuming, unfortunately. But I guess what's your best solution, or how would you go to avoid legal nonconforming if you were to get your bylaws in place? So how I look at it is, we have identified in certain zones where this kind of activity can take place, which would support the tourism within the township. So we look at that as responsible planning, putting those kind of uses in those areas. So understanding that we are doing that everywhere else, if that kind of language doesn't exist, I would interpret it from a layman perspective that since zoning bylaws are permissive legislation, if that wording exists in a specifically identified zone but nowhere else in all the other zones, it was absent. Therefore, then that would clearly define where it's permitted and where it's not.
I would have to agree with you there that the key to this is to get your zoning bylaw in place as to where they're allowed and where they're not allowed, and get your wordings in the zoning.
No, just sorry. Hey, emotions we will disengage, and we will just try to be.
I hear the audience, but basically you need to get the wording of your zoning bylaw, some thought to go into that, so it's not as onerous right at the moment. Like, you can try and enforce it, but the way it's worded, I think you need some wordsmithing there, and where they are allowed and where they're not allowed. Those type of things should be in your zoning bylaw, and that's what Niagara Falls did. They specifically said they're allowed in these particular areas and they're not allowed anywhere else. Then it goes to legal nonconformity. If they were never allowed there, they don't have legal nonconforming use. But if somebody was, I can't give you sort of legal advice on the fly, but legal nonconformity is prior to the bylaw or any bylaw being passed, you had a legal use, you may have a legal nonconforming use. And there's been some decisions recently of liberal interpretations of that.
Okay, so is there a timeline where legal nonconforming loses its right? Because does there not have to be continuous use to a degree demonstrated?
That generally was, and now there's a couple decisions that just came out, and from Ottawa, and I'm trying to remember the name of the law firm, but the one had discontinued for a number of years, but the intent was always there to do it, and the court ruled that if the intent was there, then you maintain that use. Whether I agree with the decision or not, but there's 3 decisions that just came out that are very liberal in the interpretation of legal nonconformity. And it, to me, as a prosecutor, it's troubling because people, allege that. And my way of thinking is exactly as yours, Your Worship, that once you discontinue it, it's done. But the court has said no, that there are circumstances where it isn't, but each one's specific. So you can't really give a straight answer, unfortunately.
So can I ask a hypothetical? So hypothetically, if the province was to decide to engage in this matter and hit reset and wipe the use clean and allow every municipality to, say, within the first year, identify exactly in what areas they feel would be the best for this kind of activity to take place, would that not represent good governance and good planning?
It may, Your Worship, but I don't think the province is going to do that. I don't think they want to dip their toes in this water.
No, it's just it's unfortunate because there's 400 plus municipalities in this province, and if they all spend $100,000 to $200,000, and that's going to be low on places where it's challenging, which tend to be places where there's major recreational attractions or waterfront. It's a significant collective waste of taxpayer money, being caught in a spin cycle.
Yeah. Spending it on lawyers is a big waste of money.
Yeah.
Having said that, some of the municipalities, and I can just speak to Tiny Township, which is a tourist area, but they have a very, very strong beach association, but they allow them anywhere as long as you're licensed. And so all the restrictions go on. That's the way they deal with them, but other places are different. So it just depends on the place and your needs. Niagara Falls, they've put them in the commercial type areas because they feel that that's where they should be. So it's really up to the municipality.
Okay, thank you very much. Council, if you have no more further questions, I see none. So Madam Clerk, can we have a motion to receive well, we've done that, have we? Yeah. So we'll now, do you have anybody registered to speak? I guess would be the first. So what we'll do is we'll take the people who have registered through the clerk. We'll take their comments, and then we will open it up to the rest of the chamber or those online. Please go ahead.
Thank you. We have registered, and they are in the waiting room. If they can be advanced, please. Lee and Dalius Honton.
Hello?
Hi, Eileen Delius. Go ahead whenever you're ready, please.
Well, thank you for the opportunity to comment. I had a similar question to one of the councillors about just what the resources would look like to manage the short-term rental situation better, similar to what Niagara Falls has done. And I realize there's probably not an answer to that, but that would be one consideration, just what that would look like in a town the size of Oro-Medonte versus a big city of Niagara Falls. And the only other comment I would make is that it just feels like it's been a very meandering process and frustrating for the councillors and for the public in Oro-Medonte. And I really appreciate the concrete suggestions made by both of the speakers, and hope that the council will take into consideration some of the concrete strategies that have been suggested. And even if it's going to be a whack-a-mole type of process, it still might make us all feel that we're moving forward somehow, as opposed to being kind of stuck in this this meandering process. Did you want to say something? Yeah.
This is Lee Houghton. Thank you very much to the council and especially to Mr. Spencer and Mr. Dre. One specific question to Mr. Dre. You mentioned penalties. Having gone down a licensing route, that penalties can be applied, kind of like negative points on your driver's license, if I understood you correctly. And I wondered whether with a system like that, after one runs up enough negative points, the license can be taken away. Is that the license on the property involved, or would that be the licensee, the person, and any properties that were licensed by that person?
I believe it would be for that particular property and that licensee for that property. So it, for example, if there's a property and I'm just using noise as an example, maybe you get 5 points if there's a noise complaint to the property that's justified, or there's a court action. Some of the ones that are really high are breaches of the fire code and the building code. Fire code is very high in points. If there's like no smoke alarms, no CO detectors or CO alarms, those are really, really high. So, but again, you can revoke the license of the person, but it would be for that property and that person who owns that property. That's my opinion.
Thank you.
Well, thank you very much. And not answer your question, or if staff feels they want to chime in, the cost component would be very hard for us to give at this time until a report came back on how we would what option we would look at moving forward. Okay.
Thank you.
Thank you.
Madam Clerk, could we have the next registered speaker, please?
Thank you. Nick and Sandy Reynolds.
Okay. Madam Clerk, are they in the waiting room or are they?
No, Mr. Mayor.
Okay.
And they indicated they would be in person. So if someone comes in, I can ask.
Okay.
And the third person registered is Linda Miles.
Okay. Ms. Miles, if you want to come to the, just a note, Councillor Clark has a 6 o'clock commitment, so he will be departing shortly, but we'll still have a quorum.
Don't take it personally. I have a ton of questions and I have a ton of comments, but I guess one of the things what came to mind as I was listening today is that here we are, 5 years later, after a petition of 1,500 people signed all over the township, and joint letters have come in to previous council regarding the residents' wishes that we shouldn't have to deal with this on an ongoing basis, and I completely understand that this is a very difficult situation. I've watched this through the media. I've listened to all sorts of, podcasts and information about other townships and the things that they've gone through. I've, had numerous and hourly conversations, hours and hours of conversations. And I still am trying to struggle with why, when we have a zoning bylaw that says that these types of uses are designated in V1, in a V1 designation, which is outlined and identified. And we have a bylaw that allows for legal bed and breakfasts to run if they have a site-specific exemption if they're in a residential area. So we've got those two things already in our bylaw, and I'm understanding that we still also have a commercial accommodation statement in there as well, from what I'm understanding tonight. Why is it so difficult? Why is it so difficult for the residents and the township? And this is a rhetorical question, I guess, really, at the end of the day, but why is it so difficult for these illegal uses to be controlled? And you know what? We've heard a lot about, well, there's not that many of them, and we heard that, it's only just a few of them that are, the difficult ones, the disruptive ones. Most of them are okay. But for the residents of this township and for other townships, these are disruptive, whether or not they are making noise at 3 o'clock in the morning and having parties and doing whatever. They're disruptive because they're disrupting our communities. Our neighbors are no longer neighbors that we know the names of, that we recognize the faces of, that we talk to as we walk down the street. They're just people who come there because they want to party or because they enjoy the area. That's great. That's fine. But why is it so difficult for this to be dealt with in a reasonable manner? We're reasonable people. These are very reasonable people. I thought our court system was a reasonable court system, and I'm beginning to wonder if it really is. Why? We've been at this since 2017 in this township, and there's been many of us that have been very heavily involved, and I'm perplexed. I don't understand any longer. So I just wanted to make those comments and just to remind everyone that the residents out here are still upset and frustrated. We're losing our communities. Our safety on a regular basis is being threatened, and nothing seems to change.
Yeah, no, I'm just.
That's my comment.
Okay.
Thank you.
No, thanks. And it's as simple as this. We've went before the OLT a number of times. The decisions didn't come out the way we predicted, unfortunately. We did go to the courts of appeal, and the judges took a very specific component of what was before them, which is what they're supposed to do. They didn't deviate outside the lines, and that may not have been consistent of the initial OLT hearing, where they did kind of deviate to a wider extent. But we'll leave it at that, because what I want to make sure we do.
Randy, I'm sorry, I'm going to interrupt you for 1 second. We know that, okay? I understand that you're trying to give me an answer, but we already know that. We followed this very, very carefully. So I appreciate you trying to, to give us the difficult side of it. This was just a rhetorical question and comment. That's really all. So thank you. I appreciate it. Okay. And thank you for the time.
Thank you. So once again, if we can keep the questions more general rather than specific to Oro-Medonte, because it's to be directed to our presenters and they don't know our bylaws to the nth degree. We're looking for solutions moving forward and understanding what paths we can do that are going to be sustainable and not significantly financially draining on the township. So, Madam Clerk, the next speaker, please.
Liz Kirk.
She is left, apparently.
That completes the registrations and the sign-in sheet, Mr. Mayor.
Okay. So if there is anyone in the chamber who, from the audience, that would like to ask questions or make comments, you can come to the mic. Just give your name and then continue. So, and don't all jump up at once. The gentleman in the back row. These are very polite and cordial. I appreciate that.
Hi, I'm Steve Harley. Thank you, Your Honor, and Your Worship and Council. I have a question for Mr. Dre. Have you heard of the township of Wainfleet? It's sort of in
I've heard of it, and I saw the video.
Okay, are they using the AMP system?
They're
there?
using the AMP system.
Okay. So,
all I can say is there are regulations for amps in parking, that are required, like the Ontario government have made regulations. And one of the regulations in there is that any amp in parking cannot be punitive. And it would seem that watching the video that it may well be that there are some punitive penalties being issued, and I think it's going to be challenged in court.
Okay. Yeah, it's just, I don't know if you guys have seen it, but it is quite an interesting video. Unfortunately, the guy from Rebel News is on the wrong side, but there is an opportunity there perhaps to work through that system to shut things down and everything. Nobody here wants to hear about licensing. But however, as was mentioned, there is a V1 area. There are Airbnb, there are bed and breakfast. Those could be licensed. Everything else is not. I used to drink beer and have, when I'm going fishing a long time ago, it was allowed. It's not still allowed anymore, non-conforming, whatever. It is what it is. We all have to move forward. Doesn't matter what the speed limits used to be. There's new speed limits. I have to wear a seatbelt, and that's just the way it goes. And I think that's what we should try and push for. And, like I say, if you want to go licensing, make sure it's only in those areas, and everybody else can't get a license, and it works kind of that way. But this AMP thing, it seemed quite interesting when you were talking about it, and Wainfleet was a video I saw, it seems pretty good. Just some comments, kind of try and help this thing work through. And we got to do something about that guy. He shouldn't get paid tonight.
No, that's unnecessary.
Right? He's not here, he shouldn't get paid.
No, I'm going to stop. I don't want to, we need to be respectful of everybody in the room. No, in the AMP, just so everyone knows, Mr. Shelswell is coming forward with an AMP presentation next month, because he brought that forward earlier in the year that he's been working on. So we are working towards an AMP program, which I think is much more user-friendly for the township in order to get its message across. Anyone else? Please, the lady in the back, and then, my apologies. So here's what we'll do. The lady in the back, the gentleman with the bleached white beard, goatee, and then the gentleman at the very back of the wall.
I'll be very quick.
Oh, please adjust the mic
I'll
accordingly.
be very quick. Nancy Hamilton. Just to clarify on the AMP and the licensing, that's strictly related to where our zone is zoned, the uses in those particular areas, or does it relate to the residential areas? I'm just not clear.
Mr. The AMP, please go ahead.
Yeah, the AMP program would apply to your zoning is in place first, so where they can be, and then the AMP program dovetails with that if somebody doesn't have a license, where they're allowed to be and they don't have a license and so on, but if they don't have a license in the area where they're not permitted, then that would become a violation under the administrative monetary penalty.
So with our residential, we don't want to license. We don't want any operators in residential. So therefore the AMP system does not work for us. Is that right?
No. If someone was in that area and it was operating and they didn't have a license, then that's a breach of the administrative monetary penalty bylaw.
Not sure I'm understanding.
I'll try and help out with some clarity. So, as if you heard Mr. Dre earlier say, it's important to get your zoning bylaws in place and correct. So if it was not a permitted use and our zoning bylaws were passed and were, properly structured, then the AMP would cover that anyone that would be considered an illegal use, and it would be a charge under the AMP. Does that help?
But that's only if we do want to license a residential area.
No, we're saying.
Or allow license.
If licensing is not if that use is not permitted in that zone, that then falls under the zoning bylaw. So if it's an inappropriate use, a non-permitted use, in accordance to our zoning bylaws, the AMP could be used to lay the charge.
So then would be back at trying to enforce our zoning bylaws, and no?
Yes, George, please chime in.
Thank you, Worship. I'll try to help answer the question here. So with respect to the zoning, if the zoning does not permit the use, then that particular use would not be eligible for a license. So they could not get a license because the use is not permitted. If they continue to advertise and whatnot, under the licensing bylaw, there would be provisions to say, if you're not permitted and you're still licensing, you could be subject to a fine under the AMPS program.
Thank you. That was the missing piece for me. Thank you.
You're welcome.
So we'll just refer all questions from here on in to George.
Gene Stein, Maplewood. I'm going to ask George now, and both gentlemen actually. Our zoning 97, 95. V1, Horseshoe Valley. It's already in the books that they're allowed. Everywhere else it's not allowed. On townships and municipalities that you've worked with, ones that have licensed them in their permitted areas and kept residential and not the same, what's their prosecution statistics? If we would license them in Horseshoe, where they are allowed, and they pop their little mole heads somewhere up on the lake shore, what's our clout?
No, once again, and I apologize for jumping in, but this is an educational session, and we're getting into specific matters within the township, and the questions were to be for the presenters based on what they present, and I know.
Well, I know he's worked with a number of municipalities on it, so it's just I'm still throwing out a theoretical.
Yeah, you got to use words like Whoville. You can't use Horseshoe Valley, and I'm just kidding you. But, anyways,
I really don't know exactly what the question is, but if someone's if you go to the licensing.
The question is, if a municipality...
Please speak into the mic.
Sorry. If a municipality has an area zoned for these short-term rentals.
Right.
And they license them in that specific area only. It's in bylaws. They're not changing anything.
Right.
And somebody tries doing it out of that area. Out of the licensed area with no license. What clout can come? Does that stick to zoning?
No.
Or do we get into the heavier fineage?
It's really what council decides, whether they're going to continue with zoning or go licensing. And then this secondary part of that is if you go to administrative monetary penalties. So it's a really tough question to ask. But Gerald, he said, they have areas where they're licensed. They only have 47 licensed in those areas. And they have up to, he said, if I read it correctly, close to 1,000 that aren't.
Well, they're still playing whack-a-mole, basically.
That's what they're doing there. So I'm the prosecutor. I really can't, answer that question other than the municipalities that I generally like that I'm working with, for prosecutions, tiny township, they allow them anywhere. So they don't have, they don't have a restriction. And they have, I believe, don't quote me on the numbers, 151 licensed. They put a cap of 260 licenses on. One of the other places I know initially thought they would have, this is right in this area, would have about 160, that would be licensed, and they have 31. So, and that's a city that's close to you here. Okay. So.
Thank you, Mr. Blaine.
Good evening, Council. My name is Dean Blaine. I just wanted to make one comment. I think it was Mr. Dre's presentation suggested that one of the difficulties using the zoning definitions under the Oro-Medonte bylaw was that a dwelling unit envisioned residential occupancy, and that I think that you made the comment that an STR is a form of residential occupancy. I have some trouble with that conclusion, quite frankly. I think there's authority that's comes to quite the opposite conclusion, in fact. I think, as you all know, the Residential Tenancies Act of Ontario is the provincial system for governing residential tenancies throughout the province. And it has all kinds of rules, as we know, about how one conducts a residential tenancy, both from the point of view of the landlord and the tenant. But there is an exception in that legislation that says it does not apply to accommodation provided to the vacationing or traveling public. So I think it's very clear that Ontario legislation distinguishes very clearly that something used as a short-term accommodation that is not a place of the person's normal domicile and residence is not a residential use. And I think that's very important, because one of the struggles with zoning enforcement is a notion that the defendant will claim that their activity in the of using the property as an STR falls within the scope of the dwelling unit permitted use. I don't think that's a correct conclusion at all. And in fact, in the Toronto short-term rental case a couple of years ago, before the now Ontario Land Tribunal, the chair of the OLT in that case said that short-term rentals are distinct commercial entities, very distinct and completely distinct from residential occupation. So I just wanted to point that out. I think there is clear authority that STAs, STRs, whatever you want to call them, vacation rental units in Niagara Falls, just like bed and breakfasts, actually, are not a residential use of the building. And that is a very important distinction that runs through case law in the province of British Columbia, as well as in Ontario. And I would encourage you and your council to look into that more fully. The second point I would just touch on is I didn't hear anything in the presentation about, and I think Linda touched on it, the fact that there is a bed and breakfast permitted use that is allowed as a right in agricultural and private recreation, I think. I forget, but it's certainly in agricultural, not permitted as a right in residential, is permitted in residential if there's a site-specific zoning amendment. But the bigger point, I think, is that if you read the definition of a bed and breakfast, it describes the activity that goes on with a short-term rental property. So I don't think it matters from a planning perspective what the defined term is. It's the activity that's described for the permitted use. And if one reads the permitted use for a bed and breakfast, I can't see how it's any different from what goes on in a short-term rental. So that's another thing that wasn't discussed in the presentations that I think is very important, because if we're getting hung up on the OLT and then the divisional court review of that OLT decision, one has to keep in mind that those decisions only discussed the 2020 amendment on commercial accommodation definition. It never discussed anything to do with the bed and breakfast definition, or in fact the V1 definition for a village commercial resort unit, which has been mentioned a couple of times. So all those things are still there. V1, bed and breakfast, not discussed, not affected, not touched by either the OLT or the divisional court decision on that OLT. My third comment, if I can remember, thank you for extending the time. I wonder, Councillor Young was inquiring about the standard of proof. Has the township ever considered issuing orders under Section 444 of the Municipal Act? This is not a proceeding for an injunction under Section 440, but under Section 444 of the Municipal Act, a township or a municipality, I believe, is entitled to issue an order.
Can I just jump in here?
Please.
Yes, you can under licensing, because licensing is under the Municipal Act. Zoning and the short-term rental, as you have it, is under the Planning Act. So the Section 444 is for violations under the Municipal Act. You can order them to stop and all those good things, or discontinue the activity. But that applies to areas under the Municipal Act. So, for example, an adult entertainment or a, whatever that's licensed or that's controlled under the Municipal Act, that allows you to do that. I don't believe it allows you to enter into other acts and impose that. So, if it was a fire, matter, then the fire code applies, or the FPPA. So, and the building code, they have provisions, exactly those type of provisions in there, but it has to be in the statute that authorizes it.
Section 440 has been used to obtain injunctions for breaches of zoning bylaws.
Okay.
For sure. I mean, there's lots of case law on that.
Okay.
So anyway, those are my comments. Thank you for the presentations. Thank you for your time. Thank you.
Thank you very much, Mr. Blaine. Mr. Knox.
Thank you, Your Worship, members of council and staff. It seems I was alone.
I apologize. I'm not trying to cut you off, but just state your name, please.
Oh, it's Gord Knox. I'm a retired urban planner and probably the author of a few dozen zoning bylaws and their rewrites and consolidations. Seems like I was a lot younger the last time I stood here and helped the council of the day go through the zoning bylaw, where I said if a use is not permitted, it's not allowed. If it's a dwelling, and I went through all of that, and there was no commercial taste to it. Went through the bed and breakfast situation, which again, you need a rezoning, which is, short-term rental is just a bed and breakfast without an owner. But at that time, I think for the very first time, the V1 zone was revealed, which I had discovered just days before my appearance here. And that was an official plan amendment and zoning bylaw amendment specifically for Horseshoe Valley that covered a number of opportunities for Horseshoe's future development. But in particular, the V1 zone created a definition which was specific to short-term rentals. It was designed for short-term rentals. And by the creation of that zone, from a planner's point of view, it then located an identifiable land use within a zone. Once you do that, that use cannot wander around into other zones. So maybe I could put the question to the speaker here, and it's just like Niagara Falls, because basically what they did is they put a circle around the commercial area and said, this is okay, it's not all right elsewhere. Would the V1 zone qualify as a situation where all short-term rentals outside of the V1 zone would not be permitted?
Without going through I haven't read that definition in your V1 or whatever, but having said that, what you said is correct.
Okay.
That if they're outside of that area, it's not a use that's permitted, and they couldn't get a license. And like if you went to licensing, if you stay with zoning, you see there are some issues with zoning and trying to prove it and so on, but that's a council decision.
Okay, well, thank you for that. I think we're agreeing. The other thing, licensing has been talked about here. My understanding of sections 150 through 153 of the Municipal Act, which I understand is where licensing comes from, is for a business. That's the first part. It ends with saying that it has to be in compliance with the Planning Act. So what that means to a planner is that if you are not a permitted use, you can't be licensed. Because you're not going to license a residential use, the Act does not allow that. Not an industrial use or other uses. So it's very specific to a business or retail commercial. So I would suggest to you that the only place at the moment that licensing under my understanding of the Municipal Act could be applied only to Horseshoe Valley. And the only way that you can apply licensing to a land use is to make it a permitted use and to make it a business. and we went to business, I mean, we can go to the top of the food chain, where the Supreme Court of Canada will tell you that a business, in their view, is where you make a profit from a land or an undertaking. So I think that these are lands which you are making a profit from, and you're a business. So there you go. Now, in regard to the licensing, would you, thank you. Would you agree with me then that the licensing situation should only be applied to those things, those land uses that are permitted in a zoning bylaw?
I would have to agree with that, that if you're going to get a license, it has to comply with the zoning.
Correct. Good, we're in agreement. That's wonderful.
Not arguing with you there. No.
Yep. Your Worship, thank you very much for your time.
Well, thank you. Is there anybody else? Seeing, oh, yep, okay. Just announce your name, please, and.
Hi, Connie Simo. Thank you, Council. I was just curious about the comments about the fines. I think it's most important that we do have a cost-effective process so that the township and the taxpayers don't have to pay for this. You mentioned something, I'm not sure if it was you or perhaps Niagara Falls, mentioned about a $50,000 fine for the first time and then $100,000 for the second time that they are found in not in compliance. Is there any?
Those are the maximum fines, but that Gerald was, or Mr. Spencer was talking about. You can put fines in your bylaw of up, or sorry, let me backtrack here. If you're going zoning, like a violation for an individual is $25,000, to a corporation $50,000. On the second offense, $50,000 and $100,000. But that's for zoning. But for licensing, you can go up to $100,000 for a first offense. You can also put a minimum in there. So a minimum would be $500 or $750. Like you can have a range in licensing for fines. But when he talked about $50,000, that's the maximum. And when I tell my clients, you know, that, well, we want the maximum. Well, you're dreaming in Technicolor. Like when you get in front of a judge or justice of the peace, you're not going to get the maximum on a first offense. This is a citizen, Mr. Dre, you know, they don't have a lot of money. Like I'm used to all the arguments, so you're not going to get those types of fines. So I don't want to mislead anybody here to say, you're going to get a $50,000 fine. You're not. But
well,
when
would
you,
the typical fine be starting out?
Zoning, basically anywhere from on compliance. So if somebody shuts down their operation, you know, and so on compliance for, this is zoning that I do, anywhere from 500 to likely 2,500. If they don't, then the sky's the limit that I can ask for. On a first offense, I'm just trying to remember some of the cases, like more severe. I had a salvage yard where someone was cutting up things and dumping, you know, all the bad things into a place that had groundwater. And on the first conviction, I got $12,000, and he went to appeal, and it came back, and I did him again, and that was $55,000, and on appeal it was upheld. But I mean, that's a severe zoning case where the fine could have been up to, you know, $100,000.
And if you went that route, could you also say the fines are X plus court costs?
In provincial offenses, there are no costs. So it's not like civil litigation. So the court costs are like $7.50. So there's no costs in provincial offenses courts. So when you go, it's a
But
tort.
the lawyer's costs?
There's no provision for lawyers' costs in criminal court.
Okay.
There's no provision for that. But when you sue somebody, that's a different court. That's a civil court. And just like you went to the court here, they award costs because you weren't in the criminal system. You were in a different system at that time.
Okay, thank you.
Okay. Thank you. Mr. Knox, one more question and then we'll wrap up.
Just a supplemental, Your Worship. Burlington, that was a Section 440 conviction where the judge ruled that the use should cease. The municipality could do whatever they wanted to block up access to the property, awarded $9,500 in court costs to the municipality, and basically shut the thing right down. That was the end of it. Are you aware of that case, sir? Oh, no, this has been posted for some time now, but I'd encourage you to look that one up because it's a pretty good one.
Yeah.
Burlington, tell you what, you and I will talk later and I'll let you know.
Yeah, if you have the site,
Yep.
I can give you my email address and
That's
we can go
perfect.
back
We
and
can do
forth.
that.
Yeah.
Thank you, Your Worship.
Yeah. No, so, okay. I'm going to do Mr. Crawford and then Mr. Johnson at the back. I'm trying to see that far, Mr. Johnson.
John Crawford, thank you, Mr. Mayor and Council, for doing this presentation this afternoon. You know, I'm probably not going to be popular with some of my comments today, but that's okay. That's not the first time in my life I've been not popular. Listening to the presentations today, I think council's between a rock and a hard place. You're in a really difficult situation. The second thing that I'd like to comment on is how does, and it's the zoning bylaw, how does, and is it possible for a municipality to charge when STRs have been already operating prior to the zoning bylaw?
If you're asking me, there's a possible argument of legal nonconformity, but like when the bylaws, and it has to be legal at the time they started or whoever did it. So it's a tough question to answer. You know, I don't know your bylaws, sorry, when they went in place.
Okay. So the next comment I would like to make, we had Niagara Falls, and kudos to them for doing a presentation today, but I was just wondering why council would choose a huge municipality like Niagara Falls that's thrives on the tourism industry when we have lots of smaller municipalities that I'm sure that are going through the same issues that Oro-Medonte is. I was just wondering why we had a presentation from Niagara Falls.
Well, I'll say the reason we had it is because they George, would you want to comment on that? Go ahead, Mr. Binns.
Thank you, Mayor Greenlaw. We chose Niagara Falls because Niagara Falls did have successful prosecutions, and as you heard tonight, there's a number of municipalities that are on a journey, including the city of Niagara Falls. They have had some success, and certainly recognizing the fact that Niagara Falls is one of the biggest tourist destinations in the province. They're a little further ahead because of the issues they have to deal with. So really just wanted to get that insight from a best practice perspective, and Mr. Dre did complement smaller municipalities and try to draw out some of those other considerations.
Okay, thank you. My last and final comment, it seems that like Oro-Medonte is overspending tax dollars. When out of all of the STRs that are operating here, and these aren't my words, there's only a handful that are problematic. Handful is not one of my words. Like I said, I got that from my ward councillor. There's a handful. We've spent $1 million from what I've read on this, and we're no farther ahead. That to me tells me that, you know, you're going to end up spending more money. It's just going to continue on. Do we not have better things to spend money on?
No, I appreciate your comment. I guess my response would be, this is a problem that's gone on for 3 councils. You know, so over 7 years, if $1 million, and that would be encompassing staff time, litigation, and a multitude of other matters. But you know, so we when this council was elected, we inherited some files that haven't been closed completely, and we are trying to do it in the most responsible and respectful way, taking the taxpayers' dollars into consideration. And that's why we're having educational sessions like tonight, and we're looking for alternative ways than just going to the courts of appeal or taking it to the Superior Court to keep challenging and challenging. Some things were dealt with, and we will do our best to shepherd through it in the most efficient and responsible manner possible as your elected officials. Yes, please go ahead, Deputy Mayor.
Yeah, and I think it's important to stress that, or you can't simply understress public safety in this matter. So to the extent that it matters to people and to the extent that we will spend money, I think it's fair to say that the problematic ones, a handful or not, from time to time, as we've heard tonight, can be dealt with through different processes. And those problematic ones will be the concerns of the safety of our constituents, which we will hold very highly in regard to spending your money. Thank you.
If there's, oh, sorry, Mr. Johnson, and then we'll wrap it up, because I think this has been a very informative evening for all.
Yep, my name is Dave Johnston. I'm a Oro-Medonte resident, and by the way, thank you, Council, to commend you for having this educational session. And I think Peter Lavoie's, Councillor Lavoie's comment, I think, is where we're all at here. Is we want our neighborhoods to be safe. We're concerned, such as Mr. Crawford, with, of course, the expenditure of our tax dollars, but primarily our council is here to keep us safe. But I want to take advantage of the educational moment here while we have our 2 guests, Mr. Dre and Mr. Spencer. Mr. Spencer, are you still there by any chance?
No, he is.
Okay, yeah, maybe I can address Mr. Dre then. It was mentioned that basically there's 47 licensed operators, let's call them, in a commercially zoned neighborhood, right? It's a commercial, called commercial residential, is it called? Okay, and then there's other parts of Niagara Falls which are purely residential, right? Of the 1,000, and that's minus the 47, how many of those are actually in the residential neighborhoods? Do you have any idea?
I'm not retained by Niagara Falls now.
Okay.
I did their licensing bylaw and assisted them
Okay.
through the whole process. But as I understood it from Mr. Spencer, the
Yes.
1,000 are all in residential areas. So
Right.
it's only the 47 are in that area that's where it's allowed, and everything else would have to be by zone change and site-specific bylaws if there's any outside of that.
And the fact that it's licensed in a commercial zone in Niagara Falls, and it's not licensable in a residential neighborhood, allows you to do things like the AMP program.
As long as it's under licensing, yes.
As long as there is a licensing
The
regime in
licensing
play.
program, then you can use the AMPS program for it.
Right.
And then, as I mentioned, there's certain things in there that are really helpful. The advertising, there's different things you can use, the point system, and there's various things to
Gotcha.
control the people who have a license.
Great. Okay, thank you. So, Council, my question to you folks is, of course, is that the details here do matter. The second part of it is I would be curious, to ask a follow-up with Mr. Spencer. What is the impact of those 1,000 minus 47 operators on the safety and peaceful enjoyment of people's property in those residential neighborhoods? They seem to have the same thing that we have. They have a commercial district. We do too. It's called V1. And then all the rest is residential. Anyways, thank you very much. And this is a great session. Thank you very much, Council.
Thank you.
staff.
So we're going to wrap. I'm just going to ask CAO Binns if he'd like to make some final comments.
Thank you, Mayor Greenlaw, through you to council and the community. First, I'd like to thank Mr. Spencer and Mr. Dre for their informative presentations and for sharing their extensive experiences and some of the many nuances and considerations associated with zoning bylaws and regulations pertaining to short-term rentals. I'd also like to extend thanks to Mr. Vadaboncoeur and Mr. Spagnol for their work in pulling this evening together, and for the community for coming out and participating and being engaged and providing value into the process. Second, the presentations highlighted that there is no magic pill that addresses all the issues and considerations associated with short-term rentals, and it takes time. And I think the comment was made earlier around a meandering process, which was aptly put. Mr. Dre spoke about Collingwood working on their zoning bylaw, tiny township, the city of Vaughan amongst others, and their evolving regulations. And Mr. Spencer spoke about Niagara Falls and their journey in evolving zoning bylaws and licensing, enforcing advertising provisions. And lastly, getting to an effective strategy to improve the regulations and enforcement of short-term rentals in Oro-Medonte is a priority for our community, council, and staff. And following council direction, our next step as staff will be to bring forward an options report, as Mr. Vadaboncoeur outlined in his September 11th report to council for council's consideration, and we're currently looking to do that sometime in November.
Okay.
Thank you, Your Worship.
Thank you very much, CAO Binns. And that concludes the educational section, but we're into our speed round now, so we're going to move on to bylaws. May we have, oh yes, please bring Councillor Shell back in, please.
All right.
Yes, yes, we will, as I say,
Here's your second pot of tea.
Come out.
Thank you very much. Yeah, I put it down.
Madam Clerk, whenever you're ready to count us back in, Councillor Hutchinson has a hard stop at 7.
We're on 7A, Mr. Mayor.
Yes.
The bylaws moved by Shell, seconded by Hutchison. Be it resolved that bylaw number 2024-107, be read a first, second, and third time, passed, be engrossed by the deputy clerk, signed and sealed by the mayor.
Members of council, any questions or comments regarding this matter? I'll call the vote. All in favor? That is carried. May we have a motion to, for the confirmation bylaw, Madam Clerk?
Moved by Hutchison, seconded by Bard. Be it resolved that bylaw number 2024-108, being a bylaw to confirm the proceedings of the special council meeting held on Wednesday, October 16, 2024, be read a first, second, and third time, passed, be engrossed by the deputy clerk, signed and sealed by the mayor.
All in favor? Opposed? That is carried. May we have a motion to adjourn, please?
Moved by Bard, seconded by Shell. Be it resolved that we do now adjourn at 6:45 p.m.
All in favor? That is carried. Thank you very much, everybody, and have a great week. Bye for now.